Welcome everyone. We've got a small and intimate setting today of few people, and thank you so much for being here. We'll hopefully get some audience participation from you guys. We've got a few questions to ask, and there's lots to dive into today. Who are we? WACEO. We're a non-profit association, and we're focused on supporting the decentralized future through ushering regulatory clarity for decentralized autonomous organizations. And today we are honored to have António Garcia Rolo, who's an academic assistant and PhD candidate at University of Lisbon. And we're going to be talking about the important topic of legal challenges to DAO recognition and representation. As I said, WACEO is a non-profit organization started in 2018, and it works alongside DAOs in structuring DAOs, representing DAOs when necessary as well, and also providing services through our members to help DAOs with their operations and to scale as well. And the purpose of these webinar series is to invite DAO activists and those who are in the industry to discuss and provide information and perspectives to newcomers and also experienced individuals on what's happening in the DeFi and DAO sector. And then the last one, please. As I said, we're really honored to invite António today to have this webinar discussion. It's going to be really heated in the best way possible. And he's got a great background in various crypto assets and DLT related topics. And he's written before on the legal status of DAOs, before the DAO wave happened last year and this year. And he also has experience with the intersection between securities law and the regulation of crypto assets too. So yeah, really excited to dive in. Haley, you said you had a question for the people. I think it's on the side, right, for them to answer?
Yeah, exactly. We have 2 polls here. So
2 polls on the slide.
Yeah, should I start? Do you want me to start them right now, or should we wait for?
It'll be great. It'll be great to introduce them now. And then when you guys are ready to answer them, just feel free to dive in. So, hey, António, how you doing?
I'm great. I'm fine, thank you.
Was the introduction sufficient enough?
Yeah, I think it's enough. Yeah.
Amazing. So, I think it's always good to start off whenever you're having a discussion on DAOs. You never know the level of experience that anyone has with a DAO. So it's always great to start with an introduction of the definition of a DAO, which is, despite us dealing with this topic for years, there still isn't one chosen or go-to definition for DAOs, but it'll be great to hear your perspective on what the definition of a DAO is.
First of all, thank you so much for having me. It's also a real pleasure to be here and be able to share my thoughts, which are not, as in any of these issues, they are not definite by any means, but just, well, thoughts on these new, challenging, and exciting structures that put into question some of the old assumptions of corporate law, which is also my field of study. So it's always very exciting to think about this. But well, going to the definition, well, it's daunting. It's indeed a daunting task to try to define a DAO. If I may take a step back, I do think, but correct me if I'm mistaken, I do think that the first time someone put forth a definition of DAO was Vitalik Buterin from Ethereum back in 2014, if I'm not mistaken. And at the time, Buterin defined a DAO as an entity that lives on the internet and exists autonomously, but also heavily relies on hiring individuals to perform certain tasks that the automaton itself could not do. So this is very wide, of course. Of course, he was talking when he said an entity living in on the internet, he was talking about entities deployed on a certain blockchain, naturally. And basically, he started, and I think it's a great starting point because it's a bit, he had a lot of foresight on this, actually. So he proposed, well, first of all, tackling the decentralized part. He said that unlike decentralized applications or dApps, as we all know, a DAO had some kind of internal capital, so some sort of internal property with some value, and could use that property as a mechanism to reward or to fund certain activities. And unlike a decentralized organization, which Buterin at the time described as a set of humans who interact with each other according to a protocol specified in code and enforced on the blockchain, with some voting rights and whatnot, a DAO would rely on decisions made by itself with little human interaction, or, and I think this is a great short and laconic sentence that we should keep in mind, as he said back in the day, the automaton is at the center and humans are at the edges. And at the time, he didn't, he even distinguished between DAOs in general and then decentralized autonomous corporations, with the difference that the latter would have a for-profit objective, whilst DAOs didn't necessarily have to have one. Yeah, that was, I think that's the first step. But I do think that, especially for entry-level people to understand what DAOs are about, I think that looking at the 2016 DAO experience is always a good starting point, because the 2016 DAO, which, as many of us know, was well, it was one of the biggest ICOs at the time. It gathered like around $150 million, but then got unfortunately hacked, which even led to some controversy within the Ethereum network about possible hard fork. I do think that looking at the 2016 DAO was a great way to start understanding what we're talking about, because the 2016 DAO had a relatively simple structure, and it basically any person who so they did an ICO, and every person who acquired the token would be considered a token holder and a member and owner of that DAO. They would buy DAO tokens in exchange for Ether, if I'm not mistaken. And basically, the white paper of the 2016 DAO, written by Chris outlined the grand vision of what DAOs are still about. So he outlined how to create an organization in which participants maintained direct and real-time control of contributed funds, and governance rules were formalized, automated, and enforced using standard smart contract code. Of course, then the white paper also did some grand statements about ushering a new era in corporate governance and blowing away the agency problem that exists in traditional companies. Once you became a token holder, and once the code started functioning, projects could be submitted for approval for funding by the DAO itself, and the token holders would vote on whether to fund or not, and then they could eventually receive rewards from, they didn't call them dividends for obvious reasons, but rewards for their participation. Of course, the functioning itself of the 2016 DAO had some other interesting aspects, but in general, it was more or less like this. So it gathered some attention.
If you don't mind me saying, it was quite interesting already in the DAO 2016 DAO that they already had representatives of the DAO that would take certain managerial and operational tasks of the DAO. Is that correct?
Yes, indeed. The 2016 DAO, as far as I know, they had the idea. Of course, the thing never took off because of the hack, but the idea would be to have I think it was a Swiss company, to act as a representative. So they, on one hand, I think they were probably aware of the legal challenges they would face. On the other hand, they were probably a bit more pragmatic, and of course they used an incorporated company to represent them, or they could have used a natural person as well. But one thing, and I think we'll probably return to that, I think it's always ironic, but it's not the fault all the DAOs, this phenomenon. But well, regardless of the precise definition of a DAO, there's always a constant desire, and a legitimate one, to mitigate or eliminate no, because it's a bit impossible, but to mitigate in the greatest extent possible the agency problem. For those unfamiliar with the agency problem, is basically a classic problem which permeates all human relationships in which someone is doing something for you, an agent basically. So that happens in companies because the owners of the companies are usually not the managers of the companies. So when one hears, oh, what will the shareholders think, or you see like a director or a manager of a company thinking, oh, I have to say this to the shareholders and this to the shareholders, because, well, a manager of the company, whatever glamorous the position might be, is basically a manager of someone else's money. Of course, except in those cases where it's the owner manager, especially in small companies. So there's this classic problem under which the manager's interests are not always aligned with the owner's interests. And that's the main purpose of many rules of company law, especially the ones regarding corporate governance. It's basically to balance the interests of the owners / shareholders and the managers. And the idea of the 2016 DAO, it was expressly stated in its white paper, was precisely to do away with that problem and automate corporate governance in a way in which the rules would be preset, the procedures would be preset, and many decisions will be automatic and automated. So basically, that human element, which would be unreliable, would be just done away. I wanted to make a point before I started digressing on this, which was, and it's ironic, but it is what it is, that despite wanting to solve the agency problem, many DAOs have, unfortunately, to resort to representatives because, well, then the agency problem emerges again on another level, of course, not on an internal level, but at an external level. So, but yeah, considering the law as it is, it's probably difficult to not to appoint some kind of representative with the real world.
Yeah, exactly. That you basically answered my second question already. Regarding are DAOs comparable to companies in that sense, because you mentioned about how companies have this agency issue and how DAOs look to resolve this through better aligning the incentives and also the objectives of the organization, and that alignment is made easier through blockchain as more of the transactions and interactions are transparent. Because I was wondering what the differences between traditional corporate governance and blockchain corporate governance is in that sense.
Well, the DAOs, many people, DAOs have been conceptualized and perceived using the modern company as a model or as a reference. So at first sight, some people even call them crypto companies in a sense. But however, when comparing DAOs to an existing category, one must take into account the fact that most of the decisions taken within the context of a DAO are usually solely enforced by the smart contract existing only on the blockchain. And theoretically, there is no management or supervisory bodies in the traditional sense, and therefore no obvious external representation. And that's also one of the reasons many DAOs, or most DAOs that have no legal personality, are not incorporated in any jurisdiction. One should keep this in mind because it's crucial for the legal qualification and to understand any future regulation that the inexistence of management stems once again from this whole idea, this whole ethos of automating corporate governance. But the problem is that most, if not all jurisdictions, I cannot speak for all jurisdictions because I don't know all of the jurisdictions in the world, but at least the main jurisdictions require that companies have some kind of delegated management. So that separation between ownership and control. In many cases, it's almost a trade-off for legal personality and limited liability, which also go hand in hand with one another. So it's basically the state and the legislator is saying, hey, if you want to enjoy the state-granted privilege of limited liability and legal personality, you have to register and you have to follow some rules, some internal rules on your organizations. And in fact, in most jurisdictions, companies or corporations are structured around 5 core characteristics: so legal personality, limited liability, transferable shares, delegated management, and shared ownership by contributions of the share or equity capital. And as I said, the only one that I think it's a bit incompatible with the idea of DAOs, because I don't think we can explore that further down the road. I don't think that limited liability or legal personality are incompatible with DAOs. On the contrary, what I do think is that delegated management is a bit anathema to the whole idea of DAOs. That's it.
The delegated management feature of traditional corporate governance is still seen in blockchain corporate governance as well. It's just obviously not given the ability under jurisdictions to gain that same level of limited liability that other corporate structures which have been codified into law have been given. So I think the next question that would just follow is, what is the main reason why there is a lack of limited liability protection for DAOs, even though they have this same feature of delegated management?
I think there's no conceptual or natural incompatibility. Well, one thing for sure will be lack of awareness and lack of familiarity with blockchain-based structures, of course. The thing is, I think one needs to, and I'll try not to bore you a lot with this, but one needs to think that the evolution of partnerships in companies has been a part of an historical process in which, well, the first companies with limited liability and legal personality were those colonial companies in the Netherlands or in Britain. And at the time, legal personality and limited liability was a privilege granted directly by the states in a charter and whatnot. And then only like in the late 19th century did it become available for everyone. And at the time, and I think that one of the reasons, there might be a lot more reasons depending on the jurisdiction, but one of the reasons that usually companies, or as we call them in civil law systems, like societies of capital, they are usually the reason why they have delegated management is because the legislator supposes or assumes that because they're meant to represent big companies, usually the shareholders, and well, classically they didn't have the possibility of controlling every single thing the company does, because, well, if you're like a shareholder of a big company, you usually don't have the means to do the day-to-day management, of course. And that's one of the reasons I think that leads to this. But of course, this is not very strict. In many jurisdictions, there's there's few restrictions on shareholders being managers as well. So the thing can be molded and can be adapted depending on the case. That being said, I do not think that it's an incompatible requirement, because there are already a lot of cases in which in many countries, a lot of corporate forms in which the law recognizes that there is this kind of that there's legal personality and there's limited liability, whilst recognizing that the governance structure will not be and does not have to be delegated management. I'll give you 2 examples. First of all, I think that in Germany, if I'm not mistaken, it's a recent development, but there's this new type of company called the Partnerschaft, which is, well, it literally means partnership, but it's not exactly the same as a common law partnership, because it has legal personality and limited liability. So it's not merely a contract; it's a legal person, proper legal person. And I think they're trying to mirror the English law, figure of the LLP, the limited liability partnership. In both cases, you have something even called partnership, but they are not traditional partnerships in the way that they have legal personality. They are legal persons, they have limited liability. The only thing is that the law recognizes that in some specific cases, the partners will have direct control over the day-to-day activities of the structure. And so that, for me, that's a good starting point to start dealing with those. And not only me, but some other authors, especially in the US, have proposed that approach of looking, of trying to get the best from partnership law and the best from company law, and to join them together to serve DAOs, and also emphasizing, as I said with those examples, that this is not shocking or this is not unprecedented. It's something that happens already, so we can just adapt them to DAOs. So basically having the limited liability and the legal personality, and not requiring traditional delegated management. That's what, for instance, Vermont and Wyoming, two U.S. states which have already recognized DAOs in their status books, where basically they do that. So they say, we recognize these kind of structures as legal persons. They have limited liability. They have legal personality. However, they can use a smart contract which has the following characteristics as its internal governance tool, basically. So that's basically what they say. They are very simple, but they are quite beautiful in their simplicity, because they do not go into a lot of technical detail. They just say, we recognize these structures, and we do not impose on them a certain corporate governance model. That's it. So yeah, I do not think there's any incompatibility between the absence of traditional management and legal personality and limited liability. Not at all.
Yeah, really, really, really interesting. And as you said, the corporate law develops over time. It's got a history in itself. And you mentioned that Wyoming and Vermont have already created these new corporate structures. So it's only a matter of time till other jurisdictions start developing their own too. It's literally a waiting game, or in our case, hopefully we can encourage some more jurisdictions to do this too. And one of the questions I would have following up from that would be, what would the existing laws that deal with DAOs actually contradict the DAO structure right now?
Well, as I said, existing the thing in most systems, especially, and I can talk with more propriety, of course, on civil law systems. Most systems have this, of course, that unlike the past, you don't need a charter to have legal personality. So there's free incorporation. So any person can just go up to the company house or the registrar and say, "Hey, I want to incorporate a company with these people," and just do it without any kind of further requirements, or especially burdensome further requirements. But the thing is, in many jurisdictions, in Portugal, for instance, but in France and in Germany as well, and in the UK, if I'm not mistaken, there's this principle of, we call it, it's difficult to translate, but I'll just call it, it's a typicity principle. So basically the idea that, okay, you can incorporate a company, okay, fine by you, but you have to choose one of the available structures. So usually, both in Portugal, in France, and in Germany, and Italy, and Spain, usually have the more complex type for basically companies incorporated by shares. So major companies would be like this, companies with a lot of shareholders in which the shares are securities. So those are complex, you can choose that complex big model. And then you have like usually a smaller model, which in France it's called the Société de Responsabilité Limitée, or in Germany are the GmbHs. So basically it's for smaller companies, but still with delegated management and legal personality and limited liability. So you can choose, for instance, between those two. There, of course, other types, and even different countries have different types of companies. The problem is you cannot incorporate a company in these jurisdictions without having to choose one of those pre-existing structures. Because the idea behind this, especially when it was conceived hundreds of years ago, was pretty understandable. The idea was that creditors or suppliers or clients, when interacting with a given company, they could know, okay, this company is a company by shares or whatever. So I can kind of guess how they organize themselves. So I can take that into account when I'm taking my business decisions. But well, in the age of the internet, that might not be something so sorely needed as before. And still, there's no. So the thing is, just to say, if I want to go to a company house here in Portugal, for instance, and I say I have this DAO, I want to register this as a DAO with the structures that DAOs usually have. People say, well, okay, you can register what you want, but you have to choose one of these types. And DAO is not a type yet to be chosen. And I think what they did in Vermont and Wyoming was just add that choice. So basically, you can register something as a DAO, and if you keep things open enough, you can. And because both in Vermont and in Wyoming, the law does not require any kind of corporate governance structure. It only says it has to be some kind of smart contract or something deployed on a DLT. I think that's the expression. And because it also does not impose strict membership requirements, prospective DAOs are free to just choose whatever structure they can. And that's a great approach because it gives some space, some breathing space, and some liberty for DAOs to adopt various structures. The problem is because if you don't have the DAO type or something similar to that available, once you you cannot register. And if you do not register, your activity per se is not illegal, unless, of course, you are doing some activity that is reserved for like a regulated activity or something. But if you want to do an activity that is not regulated, it's not illegal just to. If people are free to join their assets and to carry on an activity with their assets while collectively deciding on the fate of those assets and on the activity. But the thing is, if you do not incorporate in many jurisdictions, and I'm pretty sure that's common both in civil law and in common law, you'll be considered in common law a partnership, which is more of a contract than a legal person, and many partnerships do not have, at least in their basic form, they don't have legal personality. Or in civil law systems, you'll be considered, well, it's the equivalent of a partnership, but that's we call a society of persons, usually a civil society. So not in the sense of like of sociology or whatnot, but in the sense that it's basically a very rudimentary form of business organization with no legal personality required, but which basically applies some general rules to the relationship between the people who pull their assets and carry on the activity and the relationship between those persons and third parties. That, however, has a big problem, is that in most jurisdictions, partnerships have, the partners of the partnership have, first of all, they don't need to want to be in a partnership to be in a partnership. It's a kind of an automatic thing. And second of all, they will have unlimited and several and joint liabilities. So basically, if something, if there's any kind of tort or if there's a contractual breach or something like that, all partners will be liable, and their patrimony and their assets will also be liable directly, which is exactly the kind of thing that limited liability goes against. So limited liability, as we all know, you have a pool of assets of the company, usually, which creditors can resort to when there's a contractual breach or a tort or whatever. So yeah, basically the status for now in most jurisdictions is basically that. So in the absence of any kind of legal recognition or treatment, most DAOs, as long as they consist of several people joining assets to carry on a certain activity, because, well, that definition is very wide, of course, but it captures many DAOs. I cannot say most because I'm not all-knowing, but I would say that many DAOs would fall within that definition, and that has been recognized by many legal scholars in many of those jurisdictions. Is that eventually there will be in common law partnership, in civil law civil society, as we call it.
Amazing. Yeah, that's a lot of information to take in.
Sorry.
No, it's good. It's good. It's good. So just to recap there, the main difference between DAO being able to set up right now is a lack of corporate structure that facilitates them, as there's a limited number of corporate structures available in each jurisdiction. Yep. And there are some jurisdictions starting to develop structures that DAOs can use, such as Vermont and Wyoming, and they enable the DAOs to have a quite flexible corporate governance structure
Exactly.
and decide on how they want to organize themselves. But if that DAO does fall under any regulated activities, the DAO would still have to follow with certain obligations that are necessary, because that's
of course, because well, that's the thing about regulated activities. It's an activity that the legislator, the law deems that not everyone can do this freely. So we have to impose certain restrictions or certain limits. Some of them justified, some of them unjustified. For instance, and that links well, for instance, with the whole DeFi boom, lending. Lending is something that usually not all people can do. So we cannot just incorporate a company and start lending money to people because there are some not only prudential concerns but also behavioral concerns like to protect common people from loan sharks, which charge like enormous interests and whatnot. Of course, DeFi will challenge this, but I do think that's a bit utopic to think that, for instance, activities such as lending, even if then through very interesting and very open and transparent means in some DeFi project, it's a bit utopic to think that they can just exist without any kind of legal requirement, because for certain activities you have to have a license or something. Like even, for instance, even to have a store, to have a building company, you have to have some kind of license. And the problem is that, of course, that the specific laws saying to do this activity you need to have a license. Of course, they do not have to mention DAOs directly, because then you have to review thousands and thousands of laws, and that would be very impractical. What they say usually is that the entity carrying out this restricted activity must be, for instance, a company. And if DAOs, as they are done in Vermont and Wyoming, if DAOs are inserted in the wider category of company, then most of those issues will vanish. Of course, there are more sensible areas like, as I said, lending or open banking. It won't be that easy, of course. But yeah, but the thing is, once you consider DAO as a specific kind of company within the wide concept of company, you don't need, if people have problems with calling them companies, you can call them something else. In Vermont and Wyoming, for instance, I think that in Vermont they are called blockchain-based limited liability companies, and in Wyoming they are called DAO LLC. So basically, there's always the concept of the company around that. But I don't think that's problematic. It's just a conceptual thing. As long as the thing works, what do you call it? It's a bit indifferent at the end of the day. But yeah, once you consider them as a legal entity, even though a special one, well, they can carry on many activities. Of course, it depends on the activity. Some of them more sensible would require would have heavier requirements, of course.
Yeah, exactly. And this is I think the killer question which a lot of DAOs are looking at when, for example, deciding whether they want to register their DAO in Vermont or Wyoming. And this is the increased regulatory purview that they would, or regulatory scrutiny that they would be put under. And the fact that right now there isn't a clear distinction between the organizations and let's call them open source contributors on the protocol level and the DAO as an organization itself, because there's a difference between open source governance, which a lot of people are already involved in, right? You've got Linux, where there's no real company behind it, but developers can provide services for the Linux protocol, and under majority of jurisdictions, there's no liability unless they act in bad faith and intentionally code things which are incorrect. There's a few taught tests in the UK for that, and so you've got the open source governance, and then you've also got more of the operational side of things as well, which is more on building up the network and building on the network. And it's really interesting to understand the differences between these two and whether they both individually are called DAOs or whether the open source governance protocol is not considered a DAO, but the organization which manages the day-to-day activities and the different businesses that are built in tight connection to the protocol is considered the DAO.
Well, that's a pretty interesting question, because it touches upon one of the many things that differentiates DAOs from traditional organizations. Of course, if I wanted to define an organization, for instance, if I was a lawmaker or a lawyer trying to identify a specific DAO for, let's imagine like liability purposes or whatnot. Well, an organization has to have people, has to have natural persons behind it at some point, or even legal persons, doesn't matter, but at least has to have some persons behind it. And well, you need to identify that personal substrate of the organization. So you need to identify the owners, so the people who have stakes within within that DAO. Well, but then again, it's a very difficult question to answer. When does the DAO start and when does it end? Because the asset pool is not as clear cut as it would be in a normal company, which okay, a normal company owns this house or this car or whatever. So that's a very interesting and difficult question, because I'm not really sure how to answer that. Because I was just saying that one needs to think, why am I doing this? Is it for liability purposes? Then if it's for liability purposes, one needs to identify the assets in which, because if you want to sue a DAO for some contractual breach or whatever, which in smart contracts would be hard to find, but let's see, there's also a lot of questions about smart contracts and their enforceability, their validity.
Precisely.
But let's imagine it's some contractual breach. If you want to sue the DAO, you want to sue the DAO because you want money, basically. So you want money to compensate for your loss. So basically, you have to think, why am I doing this? And therefore, in that case, to define where the DAO starts and where it ends, you probably have to look at assets which you could attach or enforce. And you'd have to look at the people behind those assets. But the thing is, as the law stands now in most jurisdictions, you would have to go directly after the people, which might prove logistically very difficult. I'm not saying it would, of course, but it would be better. That's why, for instance, I defend that limited liability for DAOs and legal personality would be beneficial for everyone, for DAOs themselves and their members, and also for third parties. Because first of all, you could have a clear-cut idea where the DAO starts and where the DAO ends, and that helps a lot, especially third parties, because they need to know where do they get their money if things go south. But it also would be great for the members, because their assets would not be exposed to third-party claims, and it'd be great for creditors and suppliers, because they would have an identifiable pool where they could just reach out. Of course, that would imply other kind of rules that I'm not really sure. I think that Vermont and Wyoming do not address them yet, but eventually someone will have to address it, because different jurisdictions have, because the problem of an organization having a pool of assets and having to have enough assets so that creditors, when wanting to enforce their claims, have something to get to. That's the perennial question that exists ever since the corporate form, at least. So basically, the idea of whether you should have, like we have in most of the EU countries, actually in all of the EU countries, because that's a EU requirement, you should have the fixed and fictional social capital or equity, or if you have to do it like in the US and other common law systems in which every time you disperse assets, you need to have some kind of limitation mechanism. But well, there are a lot of course, that legal personality and limited liability are the first steps thinking about DAO regulation. But then we'll have a lot of things that you still have to think of, especially more practical things. Most of them, which the recent regulation in Wyoming and Vermont do not address: conservation of assets, criminal liability, taxes, of course, and even, for instance, if you wanted to create a DAO and incorporate it in Vermont or Wyoming, you would have an additional problem, both within the US and especially if you wanted to have some interaction with the European space, which is the recognition of foreign companies. That's also a perennial issue of conflict of laws, and or as we call it in civil law, international private law. Because, well, if I incorporate a DAO in Vermont, so Vermont law recognizes me as a legal person, so that DAO does business with, let's say, a Portuguese company. If anything happens and if I have to go to court here, would that DAO be recognized as a legal person here? well, as far as the law is now, and I'm talking about Portugal, but I could be talking about most European countries, or if not all, there will probably be not. So that will also be an additional problem. And also to determine, besides the recognition of foreign companies or foreign DAOs in this case, how would you know which law is applicable to it? You already have tons of problems with that with companies, even within the EU, which has an harmonized international private law acts. But with DAOs, there will be even more problematic. But well, that's an issue that must be thought of more down the road, especially when in Europe legislators try to think how to deal effectively with DAOs.
Yeah, like some really good points there. I think just to circle back, one of the really interesting things, for example, would be what part of the budget and what part of the treasury, for example, if you're looking at the money, is actually available to cover damages. Because typically with DAOs, what they do is, especially at the beginning where they have a very strong core team, right? They have they put a split of the treasury aside for the core team, and then a large percentage of the tokens are actually for the wider community. So if you're looking at the core contributors as who the DAO is, because depending on how you look at the membership in the DAO, for example, with a new common law corporate structure put forward by LexTex, they really separate from the contributing members and the non-contributing members of the DAO. So the non-contributing members of the DAO would be people that hold the tokens from exchanges, for example, but they're not involved in the day-to-day operations. But then the contributing members of the DAO would be the people that do are involved with the operations of the team and typically get their salary from the team stake of the treasury. And also, on top of having this team stake, they typically have a bank account as well, where most DAOs that we work with have a bank account which they have access to, and this is specifically for the contributing members of the team, right? So in this situation, it would be interesting to see whether the law would say, okay, the community, but the more open source nature of the DAO is left for the DAO itself, but only the core contributors' stake in the DAO is actually available to be taken in the case of damages, because that would start to create a clear divide between who actually are the members and like the core members of the DAO, and who can actually be discussed when it comes to damages. Because just finding Jimmy, who went on Binance and bought a smart coin and he just has it in his wallet for years, compared to Amy, who works actively on the protocol and is involved in the non-profit association involved with it. They have different roles, clearly. So this could, as you said, you have to follow the money, and this could already be a way for policymakers and regulators to make that difference, so there is that clarity for everyone involved regarding their rights and responsibilities.
Well, that's a very interesting question, but I think that the answer is simpler than it seems, because well, in normal companies you could already have various categories of members, but in this case, even for enforcement issues, well, I'm just talking for civil law, because common law, I'm not qualified in common law, so there might be something that I'm missing. But at least in civil law systems, what usually happens is that, well, companies and a potential DAO and a potential incorporated DAO would have assets, as you said. Those assets would, in the case of the example that you gave, were in a bank account. So I presume there were even like assets like, so it's a bank account with like fiat money with legal tender and whatnot. So like an account in a normal bank in euros or in pounds or whatnot. So in that case, there's no need to go. There's no need in a situation where DAOs are recognized as legal persons. There's no need to do that differentiation, because what you need to go to is go to the common asset pool of the DAO, which could involve that bank account. And if it's a normal bank account, like with legal channel and whatnot, that's logistically very simple. The bank accounts are attached every day for legal, or seized every day for legal procedures. So that won't be a problem. And the difference between status of members would only be relevant in a situation in which the DAO would be so out of money that it would have to file for bankruptcy. Of course, another issue that I haven't thought of is how would DAOs become bankrupt, and how would that work? But if it followed the traditional rules, the token holders, stakeholders, whatever, regardless of their situation, they would be the last in line to get any refund from the insolvency estate. So first of all the creditors, all the external creditors, would have to be satisfied, and then if something is left, then you would have to distribute them on the remainder. Now, another issue is, and I probably what you were thinking of, is as of now, if they are not legal persons and they have no legal personality, well, if there's some kind of contractual breach, for instance, well, any creditor, any third party could sue all the members of the DAO. Of course, there would be a practical difficulty if, like Steve, who has bought some tokens on an exchange, well, how could you reach him? Or maybe you could, but especially now with many exchanges having some kind of KYC and registration duties, maybe you could reach him. But would you want to reach like a guy who has like an insignificant stake in the DAO? But I do think that you would have to make a difference between, as the law stands today, between those who contribute more, who contributed, so the members of the core team, those who contributed more, and those who only contributed, well, just a small amount of money for their small share. But yeah, that's more complicated as it stands today, and it would be much less complicated, for instance, if DAOs had legal personality, because in that case, that wouldn't be a big problem, I think.
And then I think we don't have too much time, so I'm going to just follow up with a really brief but I think important question. Would be to understand from a corporate law perspective, if right now, with a lot of the DAOs are taking the structure of decentralized governance through an association or a non-profit, whether this is sufficient to provide the limited liabilities to the DAO. Is this already sufficient? As most of the core members would work with the non-profit organization, and if there's any issues, then it would be the non-profit that would be sued. Or is there a gap there where if a member isn't part of the core group working with the association but isn't related to it, they can also be sued?
Well, that's an interesting question, because in an ideal, if everything goes well, for instance, if a DAO is represented by this nonprofit association, for instance, if everything goes well, there would be no problems, because in that case, the DAO would, because in that case there would be a representative, so it could bind in a way the DAO. Could bind the DAO in various ways. The problem is, if things go south, and as most things do, is the nature of the relationship between that association, for instance, and the DAO itself. there's some kind of breach, there's some kind of contractual breach, there's some kind of tort, something done in bad faith. The problem is precisely what if the DAO there has no legal personality, so it would be in a fragile situation again. So if things go well, that solution, if things go well in general, that solution can be a nice one. But as Emmanuel, that everything in the law, well, everything in life goes well until something doesn't. And when something doesn't, the law has to step in. If I want to sell drugs, everything goes well. If no one finds out about this, so I'm not arrested. And if all the businesses go well, nobody would take me to court because I didn't pay enough for a big stash of cocaine or heroin or something like that. But when things go wrong, then it will go wrong for it. It will go wrong for everyone. It wasn't the best analogy, but that's the first thing that came up to my mind. Because in that case you were describing, if things go bad, the DAO will be in a fragile situation because all of its members will once again be jointly and separately liable, and the association would have the upper hand because it would be a legal person at least, and it could attack all of the members. So
yeah, exactly. This is something that's going to be really, really interesting in the next couple of years to look into. There's already been a few legal cases where DAOs and associations have been taken to court. Sadly, we don't have time to get into that now because it'll be great for us to look at those nuances and see how this will actually help develop the next corporate law structures for DAOs. I think it really brings a lot of interesting insights just reading into these legal cases. But for now, sadly, we have to get going. That I think the last person just left just now. But thank you so much, Antonio, for your time. It's been an absolute pleasure. I definitely see a lot of areas that need to be explored and researched. And I'm sure we'll be in touch very, very soon.
We shall. Well, thank you so much for having me as well.
No worries. We'll ask her later. I'm sure Haley will reach out to you. We're looking to upload these videos to YouTube.
Fine by me.
So exactly, if it's fine by you, we'll do that, and then we'll give you an update when that's done, so that we've got that audit trail. So when they need to look at how to deal with corporate law, they can see just go back to some of these questions. They've been dealt with before by Nathan and Antonio. We can share them as well.
Okay.
But Haley and Alexa, do you have anything else to add before we get going?
Oh, nothing on my end, but I would like to thank you, Antonio, for joining us today. It has been a great pleasure, and I'm going to let you know as soon as the video is ready and on YouTube.
Okay, thanks.
Amazing. All right, then. Thank you so much, guys. We're in touch anyway, so.
Well, we'll remain in touch, and and have a nice weekend as well.
You too, Antonio. See you later, guys.
Once again. Cheers.